Max Baker.
Alright, Max, we offered up some video a couple days ago of the movement video. You recall that?
Yes.
And is there a second set of video that exists from Westville that we've extracted and kind of condensed and combined?
Yes.
And tell the jury what that is.
That is the video inside of Richard Allen's cell that's recorded in kind of.
Okay, and is that video that we received through the state from the DOC?
Yes.
The IDOC record, if you will?
Yes.
And is the in-cell video, is it accurate that video doesn't have audio, it's just silent video?
Yeah, there's no audio.
Okay, and in terms of trying to condense this, again just for context, are there date and timestamps actually with this video?
Yeah, they're within the video themselves.
Okay, so it's just like you would expect to see on a video, there would be a kind of a date or a time at the bottom of it.
Yes, sir.
Along the drag bar or close to the drag bar.
Yeah.
Alright, but explain to the jury how this was condensed so that so that we wouldn't all be here for months and months and months.
Yeah, absolutely. So yeah, today, I had generated about 20 hours of video to show the jury. We've had some complications and I've, reduced it to save time and, for everyone, and these were the two videos I thought were most important. And then, when it comes to the videos.
So you just took a bunch of small files and connected them so that it's a continuous stream?
Yes, basically what I said, we dragged and dropped the files in and then screen reported our screen.
Okay.
So we just recorded that process. You will see in the video a cursor moving and dragging the file into it every now and then.
And then, with this particular exhibit, 3. May I approach?
You may.
Is this a thumb drive that has the two videos on it that we've reduced this down to?
Yes.
Now, are those videos from April 12, 2023, from 2 to 7 p.m. in the cell?
Yes.
And the second one from May 25, 2023, from 8 a.m. to 10 a.m. in the cell?
Yes.
Now, for example, with the April 12, 2023 video, it's a 5-hour block, right?
Yes.
It's 2 to 7 in real time?
Yes.
But is that even condensed down?
Yes. I fast-forwarded the video, so we're not sitting here for 5 hours.
Okay.
So it is sped up, yeah.
And were you making an attempt to do that to the point where it wasn't skipping? We weren't going so fast that it was skipping, but yet, we could show more. We could show 5 hours in a much smaller period of time?
Yeah. So basically, me and Steve Bohr accelerated the video to the point where it wouldn't corrupt the video. There's a point of negative return when you're speeding up these videos to where you're getting less of the frames and it's just kind of skipping across and it makes it look bad, so we kind of sped it up until we kind of subjectively decided it wasn't ruining the video and it was still, you were able to see everything.
Move to admit Does the video accurately reflect what you've seen in the actual raw video that we have?
Yes, it does.
And we have a year's worth of this raw video, right?
Yes.
Maybe more.
Actually, I think less.
Okay.
From Westville, yeah.
Oh, from Westville.
Yeah.
How much would you estimate we've got?
I've worked off and on the case. The last I saw of the discovery, we had up until July-ish of.
Okay.
In-cell security video.
Okay. Of 2023?
Yes.
That's the last you saw?
Yes, yeah.
Your Honor, I move to admit 3. Defendant's Exhibit 3 offered.
Judge, just note the state's objection that we discussed at the sidebar, and that is a continuing objection.
I'll note the continuing objection and admit 3 over objection with the proviso that we may have a sidebar. You may. Defendant's Exhibit 3 admitted.
Should I just give this to?
Yes.
Thank you. So, Max, the first video is April 12, 2023, 2 to 7 p.m., Is that correct?
Yes.
And this video technically, in total, is an hour and 12 minutes, right?
Yes. Defendant's Exhibit 3 published by playing.
May I advance 2 minutes?
You may.
Judge, I'm going to keep doing this just to try and move through this.
Okay.
I appreciate the court's patience in that regard.
Okay. Just let us know where you stop and start.
I will, Alya. 3:07. May I advance 2 minutes?
You may.
5:51. May I advance 2 minutes?
You may.
8:23. May I advance 2 minutes?
You may.
10:54. May I advance 2 minutes?
You may.
13:18. May I advance 2 minutes?
You may.
15:47. May I advance 2 minutes?
You may.
18:13. May I advance 2 minutes?
You may.
20:32. May I advance 2 minutes?
You may.
22:55. May I advance 2 minutes?
You may.
25:25. May I advance 2 minutes?
You may.
27:51. May I advance 2 minutes?
You may.
30:17. May I advance 2 minutes?
You may.
32:42. May I advance 2 minutes?
You may.
35:05. May I advance 2 minutes?
You may.
37:38. May I advance 2 minutes?
You may.
40:17. May I advance 2 minutes?
You may.
May I advance 2 minutes?
You may.
47:23. My apologies.
Thank you.
May I advance 2 minutes?
You may.
49:46. May I advance 2 minutes?
You may.
52:16. May I advance 2 minutes?
You may.
55:12. May I advance 2 minutes?
You may.
57:39. May I advance 2 minutes?
You may.
1 hour, 6 seconds. May I advance 2 minutes?
You may.
1 hour, 2 minutes, 30 seconds. May I advance 2 minutes?
You may.
1 hour, for minutes, 59 seconds. May I advance 2 minutes?
You may.
1 hour, 7 minutes, 27 seconds. May I advance 2 minutes?
You may.
1 hour, 9 minutes and 52 seconds. May I advance 30 seconds?
You may.
1 hour, 11 minutes and 3 seconds. Again, 30 seconds?
You may.
1 hour, 11 minutes and 52 seconds. May I continue with Mr. Baker?
Yes.
Mr. Baker, the second video, is it May 25th, 2023?
Yes.
And is this 8 a.m. to 10 a.m. in real time?
Yes.
And again, this has been condensed, just like the first one?
Yes.
Move to publish May 25th, 2023, 8 to 10, Your Honor.
You may.
This is a much shorter video, 26 minutes, right?
Yes. Defendant's Exhibit 3 published by playing.
Move to advance 2 minutes.
You may.
3 minutes on the video, 3 minutes. Move to advance 2 minutes.
You may.
5 minutes, 36 seconds. Move to advance 2 minutes.
You may.
8:26. Move to advance 2 minutes.
You may.
11:17. Move to advance 2 minutes.
You may.
14:08. Move to advance 2 minutes.
You may.
16:51. Move to advance 2 minutes.
You may.
19:25. Move to advance 2 minutes.
You may.
21:56. Move to advance 1 minute.
You may.
23:32. Move to advance 1 minute.
You may.
2400 hours 53. May I continue?
You may.
Max, you testified earlier. You had 20 hours of this video. What was your testimony? I don't remember.
Yeah, when it comes to the incel video, me and Steve Bohr have worked to compile videos similar to ones the jury just saw, about 18 to 20 hours worth of that video.
During the months of April, May, and June of 2023?
Yeah. Well, some of them were leading up to that, as well.
Okay, but we've cut all that out.
Yes.
Right? In the interest of time?
Yes.
And in terms of the April, May, and June videos that you cut out, would they be kind of similar as to what we saw today?
Yeah.
The conditions of the cell and the circumstances surrounding the detention?
Yes, yeah.
I don't have anything further, Judge. I don't know how you want to handle this monitor before Mr. McClellan crosses.
We can move it back.
Move it back?
Move it back.
Do you want me to help with that?
Yes, if you would, please. Mr. McClellan.
Thank you, Judge. Mr. Baker, in the video that we saw today, Mr. Allen is in the cell by himself. Is that correct?
Yes.
And he's got a cell to himself. Is that right?
Yes, sir.
And do you believe that it's safer for Mr. Allen to be in a cell by himself as opposed to general population?
I'm going to object to outside the scope. We laid the foundation with this. Put this video in. Max did not render an opinion about Mr. Allen's mental circumstances or his physical circumstances. It's foundational only.
Sustained.
How many hours of video have you watched with your involvement in this case?
Probably hundreds. I've watched some video multiple times. I mean, obviously, I've not seen every video. He was being recorded 24 hours a day, every day. That would be inconsumable, in my opinion, but I've seen a significant portion of it.
And the other day when you testified, I believe it was Saturday, you chose 15 of the movement videos to play. Is that right?
Yes.
And then today, there were 2 videos that you chose to play.
Yes.
And at least today in your testimony, you testified you chose those 2 cause they were most important. Correct?
Yeah. I mean, I can expand on that if you want.
Sure. Why do you think, out of all those hours of video, let's back up. Out of all those hours of video that you reviewed, why did you choose the 15 camcorder videos to play for the jury?
Well, they showed different aspects of Rick's life in the prison, so him going to the nurse, to where he meets with Dr. Walla, to, getting x-rays in one of the videos, to what the showers look like, to the incidents of him being tasered in prison. I just wanted to record all the different times he was being taken out of his cell and being taken to other places, but I did not get all of it.
So there are other videos within those that show him showering, showing him being taken out of the cell, but you chose these 15 specifically. Why did you want the jury to see these 15 specifically?
'Cause they also, I think, give an accurate impression of his mental state at the time.
To curry sympathy with the jury for Mr. Allen, right?
If that's how you want to interpret it.
To show him in what you view as the worst conditions that he's in Westville, right?
Judge, I'm going to object again to outside of the scope. I mean, this is...
Overruled. He said he picked the ones he thought were most important.
Well, what he said was we picked the ones is what he said.
Overruled.
Can you repeat the question again? I'm sorry?
Sure. You picked these 5 let's focus on the camcorder videos. You picked those 15 videos to show to the jury.
Yes.
And I assumed you'd pick those because you wanted to show Richard Allen in what you believed were the worst conditions he suffered in Westville. Is that true?
I could have picked a lot more videos and shown a lot more and it would have been just as bad.
But you?
I wanted to show more.
But you did that to try to convince the jury that Richard Allen's the victim.
Well, just as you objected to me showing your videos.
No, hold on.
Well, Judge, let him answer the question.
He's not answering the question, Judge.
Well, he's not answering it the way Mr. McClelland.
Okay. Stop.
Wants him to answer the question.
Answer the question.
I apologize, Your Honor. Can you rephrase your question again?
Sure. You showed the jury those videos to try to imply to the jury that Richard Allen is the victim here by being incarcerated at Westville. Is that true?
I don't think I was trying to victimize him. I think I was trying to give an accurate representation to the jury of what the video looked like.
But you picked the worst videos in your mind to show the jury, to give them your accurate representation of his time in Westville?
Correct me if I'm wrong, I said the most important.
Is that correct?
Not the worst. No, it's not.
Okay.
I said the most important, not the worst.
Richard Allen's not the victim in this case, is he?
No.
Abby and Libby, right?
I'd object to relevance at this point.
Sustained.
I don't have any other questions, Judge.
Mr. Rossi.
Did you pick some of those videos to show these people the truth?
Yes.
I have no further questions.
Mr. McClelland.
That's the truth as you see it though, right? Because you could have shown them other videos, and you chose not to?
And you could have not objected. I wanted to show more.
Hold on.
I have 20 hours.
Hold on.
Worth of video to show.
Hold on. The 15 videos you picked you thought were the most important out of the movement videos, right?
Asked and answered.
Sustained.
The 2 camcorder videos you picked today, why do you think those are most important?
Do you mean the incel videos, not the...
The incel videos, correct?
Well, 'cause they depict events that have been referred to throughout this trial, Rick eating his own feces and banging his head against the wall, Ozzy, that was the main reason.
And you think those are events where Richard Allen was put in a bad situation?
I'm gonna object.
That's a simplification.
To outside the scope
Sustained.
of direct at this point.
And you think those events were important for the jury to see?
Asked and answered. Objection. Asked and answered.
Sustained.
You didn't pick to show the jury other incel videos?
Objection. Asked and answered.
Overruled.
Yes. And as far as I can tell, you didn't either.
I don't have any other questions, Judge.
I have no questions.
Does anybody on the jury have any questions for Mr. Baker? Would counsel approach?
Sidebar conference conducted.
Since you work for the defense, could you confirm if the defense attorneys prompted you to choose the worst videos?
Yeah, I'm okay with that.
I'm good.
Okay. And then we're gonna break for lunch.
That's fine.
Sidebar conference concluded.
Since you work for the defense, could you confirm if the defense attorneys prompted you to choose the worst videos?
I was given discretion to choose these videos. I had viewed more of them than the defense attorneys had, and they kind of trusted my judgment on that.
Mr. Rossi.
Max, did you compile videos from December, January, February, March, where there was nothing going on except him in the cell?
Yes. And up until last Saturday, I was ready to present those to this jury.
Stuff where there's just nothing, right?
Yes.
Him just walking back and forth?
Yes.
I have nothing further.
Mr. McClelland. Up examination of Max Baker.
During the phone call were you in court when we played the phone calls of his confessions?
Yes.
I'm gonna object again to outside of the scope we're talking about.
It goes to the reasoning why he picked the certain videos he did, Judge.
This is based off of a jury question.
Well, I understand that, but he's allowed to ask. Go ahead.
Were you able to hear the phone calls that we played in court with his confessions?
Yeah, I was in court.
Were any of the videos that you played from any of the dates he made those confessions?
I don't have the dates in front of me right now, so I can't say with 100% certainty either way.
I don't have any other questions, Judge.
All right. Thank you, Mr. Baker. You may step down.
Thank you, Your Honor.
Well, ladies and gentlemen, we're gonna go ahead and break for lunch. While you're outside the courtroom, please keep your minds open. Please don't form any opinions or conclusions about anything. If please, only have all 15 of you present at the same time, and please, don't deliberate. Gentlemen.
All rise.
Jury out at 12:21 p.m.
You may be seated. All right. Is there anything we need to do outside the presence of the jury, Mr. McClelland?
Judge, could we discuss a few witness issues that I anticipate coming in this afternoon? I don't know if this might be a good time to address this.
Sure.
If you'd rather address it after lunch, Judge, that's fine.
No, we can address them now.
Could we have a sidebar?
Oh, a sidebar, okay, sure.
Sidebar conference conducted.
Are you gonna call Steve Mullen today?
Yes.
And Steve Mullen, is that just to address the issue with the police report?
Yeah, plus something else that he said. We're gonna introduce the other Ford Focus.
Information.
Ford Focus information that we had talked about, try to get the Blocher report in that we talked about. He had said on his.
You don't have to tell me anything.
Okay.
I mainly just wanted to address the Blocher report.
Oh, okay.
I was able to find some case law and I think some stuff that's applicable.
Okay.
To that. I was gonna give it to you now, so you can review it.
Oh, okay, so I could at that over lunch.
Yeah.
I'm sorry, what is the Blocher report?
The famous, I'll go grab one for you, Judge.
Yeah.
Okay. So this has to do with.
There's a police report from Steve Mullen, and it's got statements from you'll get as Jennifer got it.
Well, I can handle this, inaudible. What's going on?
The highlight was the way we received it, FYI.
Okay.
So this is a report that.
Jody? Did Jody take it?
No.
'Cause you showed it to Steve.
I don't remember.
Okay.
This is a report from Steve Mullen. From that report it's got testimony from a Master Trooper Blocher, deceased. The defense moved to admit it under 803-6, Mr. Luttrell. 803-6.
803-6.
803-6, yeah?
And so our concern is I think the police report can be admitted through that. But all the things in that are hearsay, it still has to meet the exception to the hearsay. So if they're gonna move to admit, based upon this case all the hearsay stuff, there has to be an exception to that STF. The hearsay rules still apply. So that's the state's objection.
Yes.
In that case, that's that Myers case.
Okay.
I have a hearsay exception.
Okay. Is this yours?
Yes.
Okay.
Go ahead, I'm sorry.
No, that's okay, go ahead. There's exceptions?
There's in the March 18th, I believe it was in a contempt hearing, the state, we objected to a hearsay statement, you said course of investigation, and the court overruled our objection and sustained it, so we would say this is in the course of an investigation. That's why this is going in.
I guess I don't know what exception that would apply to. I just don't know what exception that would fall under. Judge, I don't. These are his statements. I can't cross-examine, and they're asserting it's for the truth of the matter or what they're saying is true. There is no exception that it falls under.
So your exception, you're saying, is course of investigation.
Correct.
Course of investigation that Steve Mullen was conducting.
Correct.
Based on this report from an officer.
Correct.
It's Mullen's report.
It's Steve Mullen's report, and what he did was, in order to continue to investigate, he dispatched Mitch Blocher to assist him in trying to ping these phones, and then, Mitch Blocher did ping those phones.
No.
Yeah, go ahead.
That's not quite. They had dispatched send the pings, email evidence of the pings to Blocher, who was a member of the ISP, and so he looked at.
Yeah.
Inaudible.
Okay.
That speaks for itself.
Okay. All right.
Yeah.
So.
I've got the case law, I got the report.
And the next issue is Kevin Murphy gonna be called?
Yeah. He's not Odinism. He's being asked one question, and that, well, I mean, there'll have to be some lead-up questions, but...
I assume it's gonna be about how many people.
Yep.
He thinks are involved.
Yes.
His opinion?
Yes.
How is his opinion relevant, and his theory relevant to this case?
It's not his theory, it's what he heard, you know. He can testify, I heard Unified Command say, for the first, you know.
And we've had multiple witnesses testify that they believed at the beginning of the investigation it was multiple.
That was.
And they then have since narrowed it when your client was arrested, so that's in evidence. Multiple people came in and testified to that inaudible.
I think they said 2, he's going to say that it was a very specific number, it was either 2 to 3 up to 5 to 6, that was the repetitive drumbeat was 2 to 3 up to 5 or 6, and what we heard from the others is just, you know, it was more than one person.
It's his opinion. He's not an expert witness or skilled witness capable of offering opinion.
He's stating what others, at the Unified Command meetings in the morning, this is what they said.
Then, that's hearsay.
I'm sorry to interrupt you.
No, you're fine.
It's hearsay. It's already in, we've had multiple witnesses testify.
Okay. We haven't done this yet, 'cause it's awkward and I don't like the jury, like the other day, I was amazed that we haven't had this happen, the jury being out all day the other day or being out while we were debating stuff. I would like to just put, after the jury's gone. It'll take 5 minutes just for an offer of proof.
Well, you can offer proof of that verbally.
Okay.
Absolutely.
Okay.
I mean, that would be the issue. I mean, you can make your offer to prove.
I'm sorry.
No, I mean, if your offer to prove is different than the cumulative evidence that we've already heard, then.
I believe it is. I understand why you're saying that, so I will offer it.
Okay.
Verbally.
Okay.
Another thing is, I don't know what to do about this, while we're here, is we've successfully served Elvis Fields, and I know that that would not be done in front of the jury, he is not here, I've been looking out in the hall. I would ask for a warrant for his arrest for not coming in, so I don't know if you want to do that here or on the record.
Yeah, we can do that on the record.
Okay. All right.
So we're done, then.
Yes.
We're breaking for lunch.
Yes, Judge.
Okay.
Sidebar conference concluded.
Okay. It's 12:30, so why don't we recess for lunch and be back here at 1:30? Thank you very much. Jody, you can go off the record.
Off record at 12:29 p.m. On record at 1:34 p.m.
Okay. We are back on the record. Are we ready to proceed?
Yes.
Yes, Your Honor.
Is that state ready?
Yes, Your Honor.
Yes, Your Honor.
I had the chance over the lunch break to review the report that was submitted by counsel. While it does fall under the hearsay objection of the police report, there is what I would characterize as totem pole hearsay contained therein, so unless you can cite exceptions to each individual hearsay, the report can't come in. And was this yours? Did you give this to me?
Yeah. I mean, yes.
Let me give that back to you, so I don't lose it in my pile of stuff up here. Okay. So are we ready to bring the jury back in, folks?
Yes.
Okay. Gentlemen.
All rise.
Jury in at 1:37 p.m.
Thank you. You may be seated.
Thank you, gentlemen. All right. Ms. Auger, you may call your next witness.
Thank you, Your Honor.
Witness sworn.
Jamie, I'm gonna tell you right now, you're gonna have to speak up a little bit, so that we can all hear you, okay?